with regrowth planning. As we've worked our way through this draft, obviously we've seen a lot of different inputs coming in, different concerns, whether it be everything from the Public Service Commission and how they view land use ordinance from a municipal perspective, or agricultural protection. So we have multiple inputs today. We ask that everyone reserve their comments until a public comment section is available. Please mute your phones. And I want to thank also, before we get started, the Solar Law Committee, chaired by Angus Eaton, who's standing over there. Lee Gagne, raise your hand. Deborah Conrad, raise your hand. Thank you very much for all of your work. We're truly grateful. And I think I've made copies of several drafts, strike-throughs. If people prefer a hard copy version, they can leave their contact information with me, and I will print one out. So, without any further ado, again, please reserve your questions and comments until after the presenters are done. Michael Boncaro, take it away, sir. Thank you.
So, a pleasure to see everybody here, and thank you for coming on a Saturday to learn more about this important proposed law that's going to be affecting your community. To give you a bit of background as to what my role in this process has been and what I'm going to be explaining to you all today. Municipalities, when it comes to the regulation of the solar facilities and public utilities in a broader sense, they are subject to certain restrictions legally on the state level, and those that have been implemented both by laws, regulations, and court holdings with regard to how these facilities are zoned and sited. So while a municipality typically enjoys a nice broad scope of authority in the way that it chooses to regulate the land uses that take place inside of it, this is a situation, and this is not necessarily unique, but it's the one that we see most highlighted these days, where there's municipality is not going to be legislating in a vacuum when it comes to solar energy. So I'm going to give you a bit of background on that front. Just some background from me. I'm an attorney with the firm called Hodgson Russ in their environment and energy practice. In that capacity, I assist both municipalities and private developers in the development and siting of many facilities, among them being renewable energy facilities like solar. Because of that, I have seen the both sides of this issue, both from the developer perspective and from the municipal perspective. So my role today is not to necessarily act as a supporter or an evangelist for either side, but to give you a sense of what the applicable legal background here is and how it would apply to a project. So a quick overview of what I'll be discussing with you all today. I'm going to give you a short background on the treatment of land use entitlements and the kind of the overview and standards that a renewable energy developer, like a solar developer, would be held to in the local land use approval context. That's going to just entail an overview of both the traditional background on the variance, use, and area variance tests that a regular developer or an applicant before board would undergo, as well as this standard, this public utility standard, which began back in the 70s in the regulation of other utilities and has recently been applied to solar energy. We're going to track that line of cases and see how that authority has evolved over the decades. And we're also going to just go over some considerations and suggestions in light of the current state of case law as it pertains to the siting of these facilities under the public utility variance standard. And we're also going to do just a brief overview of how large-scale solar permitting is conducted by the state. So to get into the meat of this here, this is a presentation, or it's adapted from a presentation that I typically give to land use boards. So to just back up a bit, municipalities typically, when they're considering what uses are going to be allowed and disallowed within their borders, they have broad discretion to do so in the name of the public health, safety, and welfare. I think you've heard that New York is a home rule state. There's a lot of reserve power that's been delegated from the state to municipalities with their ability to regulate activities within them. So a municipality will lay out standards, what are permitted uses, what are use and area requirements in certain zoning districts, and then essentially developers or applicants for those boards, if they're seeking to have a standard not apply to them, will have to apply for a variance, which is essentially them seeking relief from those standards. A standard developer seeking a use or area variance will need to comply with a certain set of criteria. This is a list of what a standard applicant would need to demonstrate to show their entitlement to a use variance. It's essentially a very high standard, one that is near impossible to meet. They need to demonstrate that they can't generate a reasonable return on the property, that the hardship is unique to the property, that the allowed change of use will not change the essential character of the neighborhood, and that the hardship is not self-created. So this is a high standard. You see similar things in the entitlement to an area variance, which is a variance from the dimensional or lot requirements. Think side yard setbacks, maximum lot coverage requirements, things like that. You see that these factors are largely similar to the use variance standards, with just some slight departures. This is a balancing test, so a board has a lot of discretion in granting that requirement. However, these utilities that we deal with here, whether that be a conventional utility or a renewable energy project like a solar facility, are going to be subject to certain entitlements in their dealings with zoning boards and in their ability to obtain land use approvals. That's something which we broadly refer to as the public utility variance or the PUV standard. And this was the seminal case on this rather recent, so back in 2024 is a case called Natter Fruit Point Solar versus Town of Athens Zoning Board, which really kind of put the gloss on the fact that these solar facilities that feed into the grid, generate electricity for off-site consumption, are going to be considered public utilities for zoning purposes. And by extension of that status, they're going to be entitled to certain treatment in their application for both variances and just their general ability to proceed before a board and to be located in the municipality. So we'll track this evolution through a few different cases. So the first case we'd like to go over here, this was back in the 70s. This is Con Edison versus Hoffman. Hoffman is how I'll refer to it just in short. This was down in the village of Buchanan, downstate a bit. This is at the Indian Point nuclear facility, where the applicant was seeking to construct a nuclear cooling tower that was over 500 feet tall, right? In a district where the maximum height limit was 40 feet. So that's a rather significant variance, right? That's, you're looking, there's a reason why I got into the practice of law, because I didn't like math, right? But this is a lot. This is, at least more than you'd see in someone requesting a side yard variance, where they need an extra 2 feet to make a structure, right? So in addition to that large departure from the underlying, the height restrictions on the parcel, there was also some testimony offered that this cooling tower would emit saltwater vapor from the cooling process, which would then coat neighboring properties and impose a significant environmental burden on these neighboring properties. So the village denied the variance request. They applied those standards that we looked at before, and they said, you know what, they have not shown that they are entitled to this variance under that balancing test that we looked at before. So Con Ed sues, they really wanted this tower built, and that lawsuit went all the way up to the Court of Appeals, the highest court in the state. So in that case, we first get this language from the Court of Appeals where they voiced this position that public utilities, in this case, it was a modification to an electrical generating facility. When that modification is being sought, that developer should not have to demonstrate those typical use or area variance standards. And they essentially looked at this as through the lens of public necessity, right? The essential nature of what was being provided. In this case, it was electricity. So they found that because of the vast public benefit that having reliable access to electricity would offer the town and the state, that the developer was entitled to this reduced showing. So they're not going to be subject to the same kind of requirements as someone trying to operate a bar in a residential neighborhood or someone seeking to reduce the side yard setback. And the standard that comes out of Hoffman is essentially a developer needs to demonstrate that the siting or modification of their facility is a public necessity that is required to render safe and adequate service. And they need to demonstrate compelling reasons, economic or otherwise, which make it more feasible to seek a variance than to use an alternative site. So that's a two-pronged test. and there's a modifier to it. And that modifier is where the intrusion or the burden on the community is minimal, that required showing is going to be reduced even further. So this is a very permissive standard when we compare this to your typical use or area variance standard. That was a very narrow holding, right? It applied only to this cooling tower that was being constructed at a nuclear facility. So we see through the decades that the public utility standard that was originally established in Hoffman gets expanded, right? So we see this most notably in a case called Cellular Telephone Code v. Rosenberg from the 90s. This is when they were putting up cell towers everywhere, that kind of first initial push. And essentially, the Court of Appeals, in considering this case, looked at this definition of public utility that they had first concocted back in the 70s. And they said, you know what? This doesn't just apply to electrical generation. A public utility can be a lot of different things, right? A public utility, really what they look for is the character of what's being offered by the facility and their degree of regulation by a central regulatory body and the logistical constraints that go along with the siting of that facility, right? So they additionally carry forward the standard that was first articulated in Hoffman, where they say not only are these facilities entitled to a reduced showing when they're looking at their zoning approval process, but that a community cannot exclude a utility where the utility has shown a need for its facilities. We're going to go into this need concept a bit later on. So those are kind of the two main threads that we follow here. So we've got, okay, what is a utility? Once we identify what a utility is, we now see that that utility is offered for, they are entitled to a reduced showing at the zoning application level, and the municipality cannot zone it out entirely. So we then kind of saw, as the decades went on, this light appetite for the extension of this utility treatment to renewable energy projects, as was most notably voiced by the third department, so that's the appellate department of the New York court system. There's a trial court level, which confusingly is called the Supreme Court. Then there's the appellate division of the Supreme Court, and then you have the Court of Appeals, which is the highest court in the state. So this was a case from the third department in 2024, which involved a solar facility seeking a use variance. Essentially, the municipality had not permitted solar in the district where the developer was looking to construct this facility. The ZBA initially declined to extend that public necessity use variance test, and they denied the application. So the developer, 3 Point Solar, sued saying, hey, the ZBA applied the wrong standard here. You need to tell them to go and apply the right one, that public necessity standard. And the Supreme Court, the trial court, said, okay, this is pretty cut and dry. We'll send this back to the ZBA, and we'll have them go ahead and just apply the correct standard, right? So this could have been a very no headlines case if this was how it shook out. But back at the ZBA level, they denied the application again. And in doing so, they said, look, we're going to apply the public necessity standard to you here. But guess what? Even under that, you do not satisfy this requirement. And because of that, going through the record and what exactly the ZBA said, and then how the court reviewed that, we saw a lot of development in how exactly this public necessity standard plays out in practice, right? So the ZBA goes and they say, look, there's no public necessity here, right? We already have electricity. This solar facility isn't going to be giving power just to us in the town, and even if it did, we all get power from the grid, right? They also say, look, we have certain goals for renewable energy production set out in the CLCPA. To give you a bit of background, that is a piece of legislation which is really the keystone of the state's current climate agenda, which set out, among other things, goals for the production or the build requirements for certain renewable energy facilities, among those being solar energy. So they say, you know what, we look like we're going to be meeting these CLCPA goals for solar, so even on a policy level, there's no need for this facility. They also go and they say, you know, 3 Point, you were required to show us convincing evidence as to why it was more feasible for you to site this project here than elsewhere. But what you didn't do is you didn't go to these other parcels which you could have bought and explain to us why you couldn't have built it there. So the Supreme Court agrees with the ZBA this time, and they uphold, which sends it to the appellate division. And consistent with an amicus brief, which is a brief submitted by a non-party, essentially in support of a certain legal position, which was submitted by the PSC, the third department struck down that trial court decision. And they sided with the developer and they ordered the variance be issued. And we get a lot of language from this opinion, which is going to be directly applicable to what we're looking at when it comes to consideration of, what is the municipality, what is the legal framework that they're operating in when they draft the solar law. And this is really the synthesized holding as it applies to solar, right? This is the standard. So a public utility, which the standard has been applied to these utility scale solar facilities, when they're looking to site a facility or modify a facility, what they need to show is that the siting or modification of that facility is a public necessity required to render safe and adequate service, and that there are compelling reasons, economic or otherwise, which make it more feasible to grant the variance than to use an alternative source of power. And then we have that modifier again, which showed up back in the older cases we were looking at, which is where the intrusion or burden on the community is minimal, the shard required should be correspondingly reduced, right? So that tells us a lot. So that tells us that when a court is looking at what is a public necessity in terms of these utilities, they're going to look at this necessity broadly, not just at a local level, kind of on a statewide and even say maybe on a nationwide level. And it's going to depend on the kind of energy being produced and the state's policy objectives as they relate to that energy. So in terms of these renewable energy projects, we're going to look to the CLCPA. The third department conducted a review of the goals and mandates contained in there, and they decided that based on that, and based on the fact that this aligned with the state policy in terms of the increased creation of these solar facilities, that this was in alignment with policy there. And they, in terms of this compelling interest, in terms of why did the developer site a project somewhere as opposed to somewhere else, the court held that this was a relatively low burden which the developer needed to satisfy. Essentially, they said the developer doesn't need to go to every single parcel in town and explain why this parcel should be because it's impossible that we can build it anywhere else. They just need to demonstrate that it's more feasible for some reason or another to build it there than it is to build it somewhere else. In terms of these facilities, it's likely going to be the ability to interconnect to the grid. That's going to be the main priority that they're going to be considering. And they do this through the provision of hosting capacity maps and explanations as to why there's capacity on certain substations or lines as opposed to others. So if I had to pull out, what are the lessons of Freepoint and how do they apply to municipalities like Chatham today? These larger commercial solar facilities that feed into the grid, they're public utilities, and they're entitled to this lower standard under the Public Utility Variance Standard. This standard applies across each of the state's counties. The Court of Appeals denied leave to appeal on the case. So this is binding precedent for these larger commercial solar developers that are seeking to have their projects cited or having variances from requirements of local zoning codes. Capacity maps are typically what's going to be offered by these developers to show why is it feasible for them to site this location, this facility somewhere as opposed to another location. And the developer doesn't need to go to every parcel in town and say, hey, this is the only one where it's possible to build this. And this public necessity is a rather far-reaching standard. It accounts for both local considerations and broader perspectives. They'll look to kind of developer-supported grid upgrades, which often occur as part of these projects, upgrades to utility wires, grid resiliency. They'll look to the state's climate goals under the CLCPA, and from a broader perspective, the court also considered the impacts of climate change. So you have a kind of local, a state, and a broader consideration there. Some other lessons to pull out, especially as they pertain to the allowance of solar as a permissible use. A municipality cannot totally or unreasonably exclude a use that serves a broader state or regional need. This is why a municipality cannot simply zone out a solar project. It's going to be treated like a public utility, like you would treat a manufacturing plant or any other thing that needs to be piped or wired or something like that. So on that basis, an outright ban or de facto total prohibition of a solar facility is likely going to be vulnerable to challenge on these grounds. And the CLCPA, being the state's stated policy towards these kinds of facilities, sharpens that risk. Because the developer would be able to point to the CLCPA and say, hey, the state has articulated its policy on this. You know, this municipality is clearly acting against that. So in terms of, if we're looking at the path to build a durable law that would withstand potential legal scrutiny, that law is going to regulate where and how to implement these solar facilities, not whether they're permitted at all. To give you a very brief overview on the siting of large-scale facilities through the Office of Renewable Energy siting, these large facilities, larger than 25 megawatts, kind of in line with the way that the state has permitted other large utilities, is done through one single office. In the case of these renewable energy projects, large ones go through the Office of Renewable Energy and Transmission siting. The name of this office has changed a few times over the years. It's kind of been shifted around various different parts of state government. But essentially, the governing framework has not changed too much. Essentially, the goal of having the Office of Renewable Energy siting is so that these projects, which are often large, they compose multiple parcels, potentially different municipalities, can obtain a unified single permit when it comes to their development and permitting. And ORES is instructed to take into consideration local laws, public health and safety, and the same concerns which would be raised on a municipal level. But you see there I have that citation to a section of the Public Service Law. When they're making their final determination to issue a permit, their own combined permit, they do have the power to, upon a showing by the developer or the applicant, that as applied to the proposed facility, if a local requirement is deemed to be unreasonably burdensome in light of certain other requirements, including the goals under the CLCPA, the potential environmental benefit of the project, and in the case of an electrical transmission facility, the public need for the proposed project. So let's kind of take that framework and we're going to apply it forward, and you'll see this proposed draft of the law, which you'll have an overview of in a few minutes. So a wise municipality, I'd say like Chatham, which has put a lot of thought into this, is going to consider these things and keep them high in mind as they're drafting their law. So this review of, what are the goals of your comprehensive plan? How do they treat these facilities? How do they treat other potentially competing land uses? How can we protect local sensitive areas or priorities that we want to emphasize as a community while not potentially falling into that outright ban or unreasonable prohibition from that case law that I covered? It really is a balancing act, and it's an area where the state and the courts have really put some considerations which need to be taken seriously by municipalities. But with those in mind, and with the clear articulation of your local priorities, it's potential, you've got the possibility to make a law that kind of can split the difference between the two and protect local priorities while acknowledging the legal framework that exists at the state level. So that is what you will see shortly. I think we'll hold questions until the end, and we'll now move into the discussion and consideration of the law itself. So I'll tee it up to Michael Allen here, who'll be covering that.
Thank you very much. If everyone could just give me one moment to switch over things here. Okay. Thank you everyone for coming. Thanks to the Tri Village Fire Department for hosting us today. My name is Michael Allen with Regrowth Planning. I've been working with the town of Chatham now for a couple of years in trying to implement some of the comprehensive plan recommendations that were adopted a couple of years ago. And one of the things that we've been working on tirelessly is the adoption of a local ordinance regarding solar energy, because one of the things that came out of the comprehensive plan was a lot of people were very concerned about some large solar farms, solar arrays coming into town and disrupting the sort of natural beauty of Chatham and so forth. So we've been working on a draft. The last presentation we gave was actually back in February 2025. And since then we've been going through reviewing this with the Planning Commission, the Town Board, the committee that is represented here, with Angus Eaton being on the chair, So we'd like to just kind of review at a good level what some of the recommendations are that we're proposing right now in this most current draft. Actually, I should point out, if you don't already know, a copy of the draft law as it stands right now is available from a link on the town website. You can find it right there. So if you want to get back home and you want to review it in more detail, please encourage you guys to check it out there. I want to provide an overview of what the current draft solar law right now says, identify what some of the changes have been since we last presented to everybody, collect some additional public input on the draft, and then give folks an idea of what some of our next steps are. So looking back to where we were during the comprehensive plan process, one of the things we did is we did a public survey that asked a lot of questions, some of which were about solar energy. And we asked a series of questions about different size solar installations to try and get a feel for what people felt was appropriate for the town of Chatham and not appropriate. So in asking, the first in the series was, in promoting small-scale residential and agricultural solar energy systems in town, how much would you support or not support providing small-scale residential solar energy systems? That question, 56% of folks out of over 1,000 felt they were very likely to support, with 12% feeling they wouldn't really support that. When we bumped the size up to, well, how much would you support allowing a solar energy system in town for off-site consumption? That was about 20 to 30 acres in size. There was still relatively some support. 38% felt very likely to support, 28% not likely. As we ramped up in size a little bit further, we asked, well, how much would you support a solar energy system 30 to 100 acres in size? And that's when things tipped off quite a bit. A lot of people felt that they would not likely support something like that. And then finally, how much would you support a system that was 100 or more acres in size? And as you can see, much more people felt that they were not likely to support such a thing. So that was informative in writing some of the language for the comprehensive plan, where we felt, based on that, we wanted to try and keep things relatively smaller to perhaps 30 acres in size. And as Michael has pointed out, we can't outright prohibit things, but maybe we can find some different tiers of sizes and regulate them differently so that we are still providing an avenue for them while not being unreasonably burdensome. So back in November, we did the comprehensive plan was adopted. In March, the town enacted a solar moratorium on some of these larger scale developments, so we have some time to write and draft the law. In February of 2025, we had the first draft of the solar law presented. Most recently, this past March, we extended the moratorium again another 6 months. Since the last draft, we've had multiple reviews and discussions with the committee, planning board, town workshops, and others trying to make some adjustments, and also working and coordinating with attorneys on exactly what our legal strategies are here. And the moratorium that's currently in effect right now is going to expire in September. So we're looking to try and, try and tie things up so that we have something in place, because we can't keep extending this moratorium forever. We, at some point, need to lift it. So right now, the draft solar law has on the first page kind of a quick summary page that tries to break things down. There was a similar handout, if you didn't get it, at the front of the room when you came in with the sign-in sheets that kind of breaks it down similarly to give everybody kind of an overview of what the different tiers are that we're looking at. And I'm just going to go through them briefly here. So starting at the smallest level, the sort of homeowner residential level, we have the tier 1 solar. This is for on-site use. In other words, the electricity you're collecting and generating from your solar panel, you are just going to be using for your own personal use on site. That can be roof-mounted, ground-mounted, building integrated, which means maybe it's solar shingles or it's a siding on your house that can act as a solar panel that's built into the architecture itself. So it can be any of these, as long as it's under 25 kilowatts in size, which is generally the threshold that most households would be able to need. That's all done through the ground-mounted solar permit, which is a fairly, relatively easy approval process to get locally at the town. So that covers basically tier 1, and that is basically how things are operating right now in town. So that wouldn't reflect any sort of change to how things are being done. Since the last meeting in February 2025, we introduced a new, we're calling it tier 1G, G being for ground. It was suggested from some of the public comments at our last meeting that there needs to be sort of an interim size up from that for ground-mounted uses bigger than 25 kilowatts. So if you have a facility, let's say, that's looking to be generating some additional, more than, let's say, a commercial operation, you have more than, your electrical needs are more than that of a typical residential house, something to accommodate them. So we introduced the tier 1G. Again, this is for on-site consumption only, ground-mounted, but above 25 kilowatts, but the facility area, the area that it covers can't be more than 1 acre.
So is that 1 acre, 3 of those units, 3 of those big units?
Oh, I don't, that's just a photograph I took of a solar.
So you don't know how big?
Yeah, I don't know, that's just kind of represent. Tier 2R is R for roof mounted. So these are any sort of roof mounted facility where you're looking to put solar on the rooftop of a building, a warehouse, and so forth. That would count for anything above 25 kilowatts, but it doesn't have an acreage limitation because the building's already there. If you're putting it on the existing roof, we don't care how many solar panels you put. If you're putting it on the existing roof, we don't have a limit to that. You're just limited to how much roof area you have. And then tier 2G, again for on-site use, this would be ground-mounted, and this would be 4 acres max. So we're going up to another tier here where we're allowed up to 4 acres of ground-mounted solar array. And then tier 3, which is, now we start to really get into the situation where this is starting to generate electricity primarily for off-site use. So they'd be pulling in the electricity, and that electricity would be then sold off into the grid. This would be a ground-mounted system again, up to a maximum of 30 acres. And then finally, tier 4 is anything above that, anything above 30 acres. We define it in the code only because we want to say this is not allowed in the town. So anything above 30 acres, ground-mounted large scale, 30 acres would not be permitted. So going into a little bit more detail with each of these, again, tier 1, which is really designed for private residential use, can be roof-mounted, ground-mounted, building integrated, as long as it's below 25 kilowatts in size. It's really designed for private residential use. It's permitted, it would be in this draft law, permitted by right in all zoning districts. Right now, as I mentioned, this is basically how it operates right now in the town. It utilizes the unified solar permit, which is basically a 2-page permit application you fill out to get approval, and it's designed to be relatively easy and streamlined, not a lot of red tape. It's exempt from site plan review, and this represents no change from the current town policy. This is how things are operating right now. When we get to the next tier up, tier 1G, as I mentioned, this is a new one. This would be permitted by right in all zoning districts with site plan review. So you would need site plan review to get approval for it, up to 1 acre in size. And again, this is on-site electrical use only. One of the things that we've added, I believe this was in the previous draft back in February of last year. When we say on-site electrical use only, that pertains to single ownership. So let's say if you have someone who owns 2 pieces of land, it's owned by the same person, they're allowed to put solar panels on 1 piece of land, but also be able to use that power on the other property that they own. So that if they had, let's say, a farm with a piece of solar installation, they would also be allowed to use it to power, let's say, their house, which might be a separate parcel, that sort of thing, because we felt as long as the land is in the same ownership, that would be acceptable. Tier 2R, this again, roof mounted only, is permitted things that's changed since our last presentation is the size or amount of electrical generation is not capped. We don't say it's capped at 25 kilowatts or anything, but it's really only limited by the size of your roof. So if you have an existing roof, as long as you have space on your roof to put solar panels, we don't care if you're generating a lot of electricity, that's great, as long as you're keeping it on your roof. Tier 2G, this would be a special permit. This would require a special permit and site plan review, and it would be allowed in all of the zoning districts except the hamlets. So RL1, RL2, RL3, business and industrial, but it would not be allowed in the hamlets. Right now, we've reduced the maximum size from 4 acres. It was previously 8 in an earlier draft when we had presented this. Again, this is for on-site electrical use only. And a couple things that we've added to help control and contain this is it would be prohibited on ancient forest lands, active agricultural lands, unless an agricultural dual use exception is granted. And what that means is that ancient forest lands are essentially old growth forest areas that have historically never been cleared for agricultural farming purposes, logging and so forth. They've been around for quite a while, and that would require an ecologist, somebody who is knowledgeable enough to go out and look at the land, confirm that this would be ancient forest lands. So they would be prohibited in any of the ancient forest lands. Active agricultural lands, which are any lands that have been in agricultural use in the past 5 years. That is something that was carried over from the previous draft, but we've changed it. It was basically in the past 2 years. It's now within the past 5 years. And the ag dual use exemption allows an existing farming operation, if it's an actual legitimate schedule of farming operation, and they can demonstrate that they're using the solar panels on the same land with an active agricultural activity, then they can be granted an exception for using it on agricultural land. And that would be by a special permit. And again, the facility area also cannot cover more than 50%, or 50% of the facility can't cover what we call mineral soil groups 1 through 4, which are generally higher quality soils as defined by New York State for farming, such as prime farmland soils. So no more than 50% of the facility can cover those types of soils. There's also a townwide cumulative, this gets complicated, but I apologize, but there's a townwide cumulative cap to how much of these soils they can cover. So if you have multiple facilities, each covering a little bit of percentage of these soils, there's a 2% cap overall town-wide, because we don't want to be giving up key soils, key agricultural soils for some of these. Moving up to the tier 2G, continuing. So as I mentioned, the cumulative area of all the 2G and tier 2-3 systems cannot occupy more than 2% of any of the MSG soil groups 1 through 4. So the idea behind that is to prevent death by 1,000 cuts rather than each facility coming in and taking a little bit away. There's a cap town-wide. And then in addition to those requirements, this tier includes some additional requirements that talk about how fencing should be done, their setbacks, height, lighting, screening, native vegetation, signage, underground burying the lines, the power lines, pest management. And one of the things that we've added more recently is in the review of these projects, the consideration of some of the recommendations of the community preservation plan in terms of what areas of town we feel are most sensitive and qualify for protection. Moving up to the tier 3, which is the highest allowed under this code. This would be allowed only with special permit and site plan review in the solar overlay zone, which is a new zone that we're proposing, that you would only be allowed to build within that zone. The maximum size of the facility would be 30 acres. Again, this would be probably most likely for off-site electrical generation. So it would be collecting energy to feed into the grid somewhere else. Just like the previous tier, this would be prohibited in the ancient forest lands, the old growth forests, active agricultural lands, unless they can get an exemption for being able to do the agricultural dual use. The facility area, similar to the previous tier, the facility area cannot cover more than 30% of mineral soil groups. So in other words, the previous tier was no more than 50% of the facility area can cover those soils. Here it's lowered to no more than 30% of the facility area can cover those special soils, and we still have the town-wide cap. The cumulative area, as I just said, now goes down. It can't occupy more than 2% of each of these soil groups. And then the new thing that we've added in this is just an overall limit to the number of these systems that can be installed in town, where we're putting in no more than 3 tier 3 projects would be allowed in the town of Chatham. So that would be a new sort of safety valve or cap on this. And like the previous tier, this also includes special requirements for many things such as fencing, environmental, wildlife signage, but we've also included additional requirements related to sound, requiring a community benefit agreement, consideration of community preservation plan, as well as requiring them to have a maintenance agreement and a decommissioning plan, so that if the facility, the owners for some reason go bankrupt, that they can't just walk away. There's money set aside that will cover the dismantling and restoration of the site. So, the last tier, as I said, should be defined in the code only so we can say it's not permitted in town. Tier 4 is defined in the code, but it's not permitted. And as Michael has explained, New York State can still come in and override that. It can come in and say, we're going to override that locally and still cite the facility here. What we're hoping is with these different tiers and the fact that we've done our homework on some of the different areas, what parts of town we don't want and what parts of town we would allow it, we are still finding an allowable level of areas where they could be cited. So we're hoping that we're not being unreasonably burdensome. We're still allowing the facilities up to 30 acres. If the state were to come in and override it, we feel that the systems and so forth that we've developed in this code would still apply to whatever system that they put in. So in other words, our requirements about a decommissioning plan and siting and fencing and so forth, those are still reasonable restrictions or conditions to put on their system, and those would still apply going forward. So similar to the handout that I provided at the door, this kind of gives an overview of how they all work, starting with tier 1, maximum size 25 kilowatts, but it doesn't really have any other conditions. As you move up to tier 1G, there's a 1 acre limit and site plan review is required. We go to tier 2R, it's really limited by roof size. Tier 2G, maximum size is 40 acres, but site plan review is required, special permit required, ancient forest limitation, active ag limitation, and MS soils limitation all kick in. Then we go up to tier 3 with a maximum of 30 acres, and all the same conditions apply, in addition to the fact that it's only permitted within the solar overlay area, which I'm going to go over. And then tier 4, we're trying to say the community has spoken in our comprehensive plan, we're really not looking for anything bigger than that. So, going over some of those caveats or controls, the ancient forest lands, as I mentioned, those are wooded lands of the older growth trees that have really never historically been cleared. Those need to be field verified by an ecologist, but we have some mapping that gives us some idea where they are. The mineral soil groups that I mentioned, these represent kind of the best soils in town. That's the soil classification that's developed by New York State Ag Markets. Mineral soil groups 1 through 4 consider some of the most productive soils. This is a map showing their approximate locations in different shades of green. Approximately 23% of the town of Chatham contains these soils. So as I mentioned, there's a cumulative cap that all of the different solar facilities that are discussed in this, they can't occupy more than 2% of the MSP soils in town, so that gives us kind of a stopgap to them being cumulative effect covered by the different areas when we go out that, and we started to then take that and refine it and look at selected areas based on how far they are from state roads. We want to avoid stuff off of local town roads. We want to avoid areas of prime soils, priority conservation lands, and so forth. So what has been developed is the solar overlay zone that we're looking at right now. So this would be for tier 3, would be 2 small areas in the southern part of town near Chatham Village. It's approximately an area which extends about 1,250 feet out from Route 203 as it passes through town here in the southwest corner of town. And then also on Route 295, extending up from the village out here. So it's basically going from about where Kinetic Fitness is of the farmer's market up to about where 295 branches off on the new Concord Road, roughly. So that's the area that we're looking at right now for the solar overlay zone. So all of the proposed or all potentially tier 3 systems would be relegated to those areas of town. And we feel this is striking a reasonable balance between banning stuff outright and providing some area for new lands to come in. So we have those 2 areas shown in a little bit more detail. This is the boundaries of Chatham Village right here, just for context, and the 2 main corridors going up there. So that is the area of land that we're looking at right now for the solar overlay. And just quickly, the actual use exemption, just to give you a little bit more information, it allows an exemption from putting solar facilities on active agricultural lands, but it must be an active Schedule F farming operation. There must be provisions for monitoring and inspection, so periodically someone needs to be going out there and making sure they're actually still farming the land, and it's not just they weren't being played. And if they fail to maintain the agricultural operation that they were granted permission to do, then the special use permit would be revoked and they would no longer be able to do the solar. So a quick overview of changes. We added the intermediate tier 1G. We lowered the 2G tier down from 8 acres to 4 acres. We added the ancient forest lands as a limitation. The solar overlay was added as a limitation to the larger tier 3. We added the dual use agricultural expansion, so farmers who would still want to do solar can still have that option of doing it. And then also, not mentioned before, the use of lithium-ion battery energy storage systems, which are really designed for off-site principal use, those would not be allowed. So a battery energy storage system on site that is just storing energy for the grid overall by itself would not be permitted. So we're going to open it up to questions and comments. From today, we'd like to kind of leave the comment period open for a couple weeks. And we're going to take all the comments. The solar committee is going to review comments, and we're going to look to make any adjustments. As I mentioned, the moratorium is going to be expiring in September. So with any luck, hopefully we can wrap things up, and then at that point, go through whatever public hearing process is necessary before the town actually adopts this. But we're aiming to finalize the code before the moratorium expires. And oops, that transitions slowly. But actually, I'm going to skip ahead. One of the things that are on some of the handouts, the summary handout, is vote cards that look like this. If you know somebody who wasn't able to make it today, we have a comment form up on the web, and they can provide comments. Or if you get home and you think of something that you wish you had said, you can use this to provide any comments. And other than that, I want to kind of open it up to questions. No offense, Angus reminded me of something.
We're saying 2 weeks forward. We put on the website earlier this morning that we would accept comments until close of business on July 6th. So just,
Okay, so July
not
6th.
to step on you, but
No.
it's a little bit more than 2 weeks.
A little bit more. Okay. There's somebody in the back that had their hand up, yes?
Yeah, the map that you showed, the solar overlay.
Yes.
Is there any way I can access that online? Is there any way I can access that?
Well, yes, I mean, one of the things I'm hoping to do, I'm recording this meeting today, and I'm also planning on sharing a copy of my presentation. So with Angus's assistance, or any of the town assistants, I can have a copy of my presentation and the video on the town website Monday.
We can put a standalone map of that proposed overlay on the website as well.
It's on the hand,
Yeah, it's on the handout, but
Oh,
in case people don't want to search within a document, we can do it.
Okay. Yes, in the Greenswater.
Yeah, could you explain with the overlay zones, I assume that's private property? How does that work, that you're basically saying private property is open to solar development, but you don't know if the owner's open to solar development?
Well, that's the way it is right now. Anybody with private property could say, I want to put solar on my property, or they could be approached by a developer and saying, would you let us put solar, or can we just buy your land? That's no change.
So this is the only land where a larger solar, whatever it is,
Yes.
Tier 4 could go
Yes, tier 3.
at this
Yes.
point? Okay.
Well, right now, as things stand, there is no control over that. What we're hoping with this new local law is that it would provide some additional control and limitations. So, yes, sir, in the blue shirt.
Yeah, two questions. Tier 3, you reference a community benefit agreement which talks about pilots rather than paying taxes like the rest of us.
Yes.
Why would it be a pilot rather than just regular taxes based on assessed value?
I'm not sure. I do know that one of the things that we wanted to have in this law is provision that they would need to come to an agreement with the town on what sort of benefits they would be able to provide, and that might be monetary, or they might be constructing something. I believe Angus or supervisor might be able to go into a little bit more detail with that.
Well, they're exempt from taxation under the law, from the state law.
From
Solar farms?
all utilities? Or just
For 15 years, I believe.
renewable utilities or all utilities?
I only know about the solar.
Okay. Second part of the question, Michael, if the law were in effect as proposed, and Shepherd's Run were proposed here, what would be the impact of that?
I'm only vaguely familiar with Shepherd's Run. I don't know the details of it. You're talking about as far as how big the facility
It's
is?
a 200 acre somewhat.
260, yeah.
Well, unless, I don't know if in that case, the state overrode the local jurisdiction. Yeah. Then what we would hope is that some of the conditions that we've included in this local law, such as asking for some of the community benefits, the decommissioning plan, and many of those details and so forth, that those would still have force. And I think we're backed up somewhat by the fact that this is all backed up by what we've heard from the community during the comp plan and what we wrote in the comp plan. I believe would help support that.
If I could just weigh in just from perhaps a more drier, more legal perspective, what would likely occur is that the developer seeking to get that project through would probably be able to demonstrate to the Office of Renewable Energy Siting that that total ban is unreasonably burdensome, but they would still be subject to the substantive aspects of what is laid out in the law. Because in the law, it's written that those Tier 4 facilities, while not permitted, if the state were to come in and override that, they would be subject to the Tier 3 system requirements, which take into account, visual screening and other kind of conditions like that. So the idea is that it would disincentivize it, but if push came to shove, I think a developer would be able to challenge that. But at the end of the day, it puts the ball in their court. They're going to need to come forward and bring that challenge.
And I believe, I'm not the lawyer here, I believe they would need to show that we were being unduly burdensome.
The burden is on the developer to demonstrate that.
In the pink, I believe.
Yeah, in the handout here, you have a sentence for the solar overlay zones that they may be adjusted in the future based on changes to infrastructure, tech, and landowner interests. What is the process to adjust?
That would have to be approved by the town board and would have public hearings and so forth. It would be much the same as any zoning change. So there would need to be, much like the process we're going through right now, there would need to be at least a couple of public hearings, maybe some public meetings, just to have that adopted. So there would be a public process. I don't know if right now aren't any caveats in this law that state any limitations to how much that can be varied. But right now we're leaving it open to having some flexibility in the future.
I did have one additional thing.
Sure.
I just wonder, with the team working on this, if they put any consideration on view shed from conservation areas or other critical environmental areas. I know that there's limitations on ancient forests, but was there any consideration for other natural resources?
I'll just answer, and I'm sure one of the other members could chime in. We did look at ridge lines as a consideration, but a couple things. Number one, the ridge lines maps that we have are considered right now to be flawed in some ways, and that one of the goals, overriding goals, I think it's in the I'm sure it's in the comp plan, is that is to find areas which aren't necessarily flat and good ag land where siting could happen, and ridge lines might fit that. That's number one. Number two, there are actually no critical environmental areas in Chatham.
I know.
That would not come into play. It's a
Or conservation areas, sanctuaries?
yeah.
No?
That wasn't part of the consideration.
Okay.
Yes, sir.
I'm mainly interested in the limitation on active ag lands. And I guess my question is, it bothers me a little bit, this ag use exemption. And who would be making the decision what's a valid ag use exemption?
That would be limited by or approved by the planning board as part of the special permit application.
And could that, if you didn't like their decision, could that be challenged?
Yes, any decision of the planning board can be appealed. So yes.
Can you just give me, you showed one picture with sheep. I used to have a sheep farm, so I know that side of it. And what else would be an example of an ag use exemption?
Well, I believe
In here, I just want to go to the part of the code where we talk about that. I know at some point in earlier drafts,
we had listings of permissible ag use exemptions, and I just want to refer to that. I apologize. We've gone through many drafts and changes of this. It's hard to remember everything that we don't and do still have in here.
I want to say it should be limited to just grazing and cropping. There
Because
was
at one point we did list a list of.
right. At one point there was in the ag and market stuff, very long ag and markets definition. There was things like apiaries and so on, and the committee looked at that and said, I don't think that's not what we're looking for. We're looking for a higher use than.
In other words, we didn't necessarily want to set it up where somebody could say, oh, we have a beekeeping operation, they let 3 or 4 bees go and call it that. That seemed like that was gaming the system, and we were worried that.
That's what I'm worried about.
Is that how you remember?
Yeah, a lot of times they do use the hives as window dressing just to get through, but so we obviously want the planning board to review this.
And if they got the ag use exemption, would they still be subject to all the requirements for visual protection and everything else?
Depends on the size of the operation. The higher tiers have those requirements for, but I believe there might be a situation where you could have a lower tier operation, maybe it was, I think I want to say the 4-acre size, that didn't have all of those very specific requirements.
Right.
That wouldn't apply in that case,
But the dual use exception itself does not exempt you from those other provisions if they were to apply.
that only limits where you can put it. So it doesn't get you out of the other requirements as far as the things that standards you have to meet.
It would exempt you from the agricultural land requirement, but not the rest of all the other ones.
Actually, in one of the earlier drafts, we also had an exemption for the mineral soil groups, looking at the soil, and through a series of back and forth, we ended up taking that out because we didn't feel there were some issues with it, so we just kept it for the agricultural lands. We figured the folks that are going to be using the ag soils are probably going to be ag-related uses anyway, so that was somewhat of unnecessary limitation. So.
Okay, good, thank you.
Yep, this is the back of the hat.
Yeah, I'm curious where you got the term ancient forest from.
I know this druid. No, actually, I'm not sure how that came about.
Yeah, I work in the timber industry. It kind of means nothing.
Was that farm ecology?
Yeah, and especially applied to this town, it really doesn't exclude any land. It is something that will be very easy to punch the line in the future.
Okay, that's a good point. As somebody in the timber industry, would there be a way of defining this that you feel would be?
Yeah, if your objective is to protect what the public would perceive as forested land, like as you drive the roads of Chatham, using that term would allow almost anything and everything you see with a tree on it to be sold.
That's not true, it's actually a state definition. It's a state
It
definition.
it's not, it's like implying old growth, but even if you use the term old growth, what is the criteria of old growth forest? Like the amount of Chatham that would have that
Is a small area.
is less than I think what your blue map is showing, like, because you define it as never been logged, never been cleared for ag, like, people need to understand how much of Chatham has been cleared for ag, and when you're going to, like, the scales that a solar company, like, money is gonna bring here to challenge that definition, they will find ecologists that will allow you to clear your land. It's a bad way to, and to use it the way you guys are, it's a massive hole.
Okay, the idea behind it
I don't know
is
what the better term is.
if we're telling folks, we want you to avoid all this farmland, what's happening is we're pushing them toward the parts that.
Yeah, you basically say, here's a field that hasn't been hayed in 25 years and is all shrubs, but here's a 30-acre forest. We can cut that 30-acre forest down.
Okay. So in other words, it would be good if we could better define what we mean by these.
Yeah, we need a better definition, for sure.
Okay, yes.
First of all, thanks to the town for changing the date of the meeting. Because we got a lot of pushback, but not a lot of applause.
Well,
Thank you.
it'll be a good turnout today, so something went right.
Yeah, no, I think the plan is dramatically improved from the first iterations. I'd like to make one suggestion. In the several places, tier 2 and tier 3, and another place in your slides, but maybe not in the plan, where you say consideration of the community preservation plan. In addition to that, I would have consideration of the municipal farmland protection plan, which was passed by the town in 2009, adopted by the county, and adopted by New York State and markets. It was then updated in 2023, but it has a goal of zero net loss of working farmland in it, which was adopted by the town, the county, and the state. Even though Mike was convinced me that none of this will, if they want to do it, they're going to find a reason. I think we should have as much in our law as possible as a preemptive defense.
Okay, that's a good point. I'm wondering if the farmland protection plan is already incorporated into the community preservation plan, but
No,
that may not.
They're aligned, but there is language in the farmland protection plan specifically about the zero net loss.
Okay. Yes, sir, in blue fire shirt. Everybody brought their fire shirts today.
I just want to say that this is a very inconvenient day for me. We were at the Canaan Community Day, but I like to come here. question about those overlays. Specifically, I was thinking about the one that, of course, most impacts me, which is from the bowling alley, or former bowling alley, to New Concord Road. And that has very close proximity to the Stony Kill Creek and other areas that are used occasionally by people for fishing and hunting. And also, again, is there something we can do to clarify that there are certain things that shouldn't be occurring that close to such a major creek? There's also the Indian Creek. I don't know if you remember Indian Creek up by Clark Road, for example. That was one of my questions. And the other one was with decommissioning. Is there some way that we can, instead of having a decommissioning plan, is there a way that we can implement a requirement that actually requires monies to be put in escrow? And then legally, okay, and then to a sufficient state to return the land to its original state, meaning right back to, which I would expect would be quite large in terms of an expense.
I want to say that.
Is there a way to set a threshold, basically, so that we make sure that these sort of companies actually have money set aside that can clean up after this mess?
I want to say that that is in here, but let me double check.
With a 5-year review. So every 5 years it's reviewed.
Right, in case something needs to be added.
That's
a change in expenses for.
So it says that it has to provide a decommissioning security with the following requirements: deposit excavations with blah blah blah, cash, land, or bond, or other form of security reasonably acceptable to town attorney and engineer shall be in the amount sufficient to ensure the good faith performance of the terms and conditions of the permit issued pursuant thereto, and to provide for the removal and restoration of the site subsequent to removal.
Would that include the removal of contaminants? Soil contaminants?
Maybe there's a couple more
I mean, I do,
Yeah.
testing and removal of soil, testing for and removal of soil contaminants.
We can make sure, so the decommissioning should include testing.
For and removal of soil contaminants, soil or water contaminants actually might be better.
I believe in some of the ag markets language, they talk about taking off the top layer of topsoil from these areas and stockpiling it somewhere. I don't know how well that actually works in practice, so that if this facility is taken down, decommissioned at some point, you take that down and then replace the topsoil so that is I guess spoiled, if you will.
Right.
I don't know if that's a reasonable.
And yeah, Rick was just mentioning, these the new panels, I guess, don't have some, what I might say PFAS is what you're talking about. So the PFAS and the other coatings that have come into question, but 20 years ago that wouldn't have been considered an issue. So if we could be a little thinking about the future and saying, and any future identified substances which may be considered at that time to be a pollutant.
Future identified, yeah.
Well, because right now, let's say if this thing was 25 years ago, right, and it was going to be decommissioned, what's PFAS? They had no way of accounting for that. They wouldn't have put any money aside for the removal of that, especially if it was contaminating an aquifer or their water supply.
Right, okay, that's good. So testing and removal of soil contaminants, including future identified contaminants.
Right.
And also you mentioned the five-year review of the decommissioning plan.
Right, and then the 5-year review would include all the components of the panels that may have been identified as harmful to human health or wildlife.
Sorry, just trying to catch up. Human and wildlife. Okay. Who hasn't had a chance to go? Yes.
So with your dual use exemption, so like let's say you wanted to grow like broccoli, would those like under your solar panels, would those, or berries or whatever, would those soil restrictions apply in that circumstance?
No, we had at one point soil limitations, providing an exemption for dual use to get around soil limitations, and we decided that kind of counterintuitive, or it would counteract what we're trying to promote.
So like, what if you wanted to graze cattle under solar panels, for example, would those mineral soil groups still apply?
They wouldn't prohibit it.
Like you could still put it over the better soils because in theory you're growing things or you're trying to
Yes,
grow
right now,
crops.
as it's written right now, the ag dual use exemption isn't limited by the soils on the parcel.
which talks about like, the roof mounting the slopes.
As far, and we
Yeah,
go to.
maybe I'll ask the committee that question, because you might not know that.
You mean these tiers, right here?
Yeah, it's in tier 1.
I think we just carried forward the existing limitations.
Right, the unified, tier 1 mostly came from the way the unified New York State solar permit comes from, is basically cap that. you
Yeah, I
can't
know
do.
that.
Okay.
So, but I wanted to know the committee's rationale for, because it looks like that would ban pop-ups. Like if you wanted to put your solar on the north side of the roof and have it face south,
We did look at that, I think it doesn't.
it doesn't, okay.
But when you look at it, I have to go back in the language.
Sorry, I'm not sure, I want to make sure I understand what you mean by banning the pop-ups.
So like if you wanted to put your solar panels on a northern exposure roof, but you wanted it to get the southern exposure of the sun,
Oh, so it's.
instead of having it lay flat, you have it,
So now I'm understanding what you're saying, I
Yeah.
don't think that would be allowed under this law.
like, yeah, so you ban that.
Well, we don't allow
I think as a, right
That's
now,
my question.
as it's written,
What's
the
your
solar
rationale
panels
for
basically
banning
have to be
that?
mounted, like, kind of in line and flush with the roof.
Yeah.
And if you were trying to, if you had a roof like this, and you were trying to put your solar panels like this, facing the opposite way to get the sun from the other direction, that's, I think as written right now, that would violate the code.
Well,
Also, my boss can make
she's
it
talking about
fire.
changing the slope on the north face with the,
Yeah, so your roof is like this, and like you put the panels like that instead of laying them flat to catch the sun.
Well, it just says it can't be higher than the ridge line of the roof. I didn't catch anything about what direction.
No, it says it has to be within 12 inches of
Oh,
the
yeah.
roof, which bans that.
That would apply.
So the reason I bring that up is because that happened in Lebanon. They just plug and played the law without knowing what it was that they were regulating. But the solar companies know that. So somebody did actually have limited roof space, and they wanted to put it on the northern side of the roof. So I hope you. I mean, what's your
it's a
rationale?
comment. We'll look at that.
How do you want it? I mean, that's all.
Okay.
Sorry.
Who else? I'm having trouble keeping up with all the hands, and now they suddenly disappeared. Where'd they go? Who hasn't gone? Yes.
Regarding Tier 1G, you said that, it's 110% personal use,
Yes.
which makes sense to me. But what if the lots are not contiguous? What if my residence is a quarter of a mile away from my agricultural operation, and I put up enough solar panels to cover both my ag op and my residence, but they are not contiguous lots? There's a bunch in between.
We don't have a problem with that if you can make it work. I mean, if the town wanted to put solar panels on the town garage but still use that power to power town hall, that would be something I think folks would be on board with, considering town garage doesn't use a lot of electricity.
Yeah.
You can think of similar examples here at the firehouse. I'm sure they could benefit from something like that. So we didn't want to. Now, obviously, there's logistical challenges to that, but we didn't want to limit it.
Yeah, that makes sense. Just wanted to make sure that it was allowed. And then, I know Hodgson Russ advised the town against the 3 cap on the tier 3s. What about the cumulative caps based on soil types?
I think it's a closer question than the court has ever heard, so it would make some interesting case law if it came to, push came to shove. The interesting thing about where things stand in the public utility space as they pertain to solar is we really just have the 3-point case. We thought there'd be a slew of cases kind of iterating on 3-point and kind of giving us the contours of this. A lot of it is still gray, right? So those cumulative soil coverage caps, I can make an argument either way, right? I think that it's a much closer question. I think that you have very firm ground to stand on as a municipality regarding your priority of the preservation of your good agricultural land. And it's a question it's always gonna, whoever gets burned, right? Whoever comes and they say, hey, I can't build here because this cap is in place. This is the fact, this is an outright ban on solar. And that's the argument they take. They say this is an outright ban, this is not permitted under, under that line of cases we looked at.
And maybe
So that'd be their argument.
we can avoid that by, this might not become an issue until we reach that 2%.
Oh, yeah, it would take a number of projects to get there, but, they're coming.
Yes, sir, in the back, also fire shirt.
Yes, I'd like to understand this from a tax perspective. I'm under the impression that the land won't be taxed if a tier 3 or tier 4,
Any tier.
any tier? Okay.
Well,
The improvement.
So that goes, so immediately it causes all taxpayers' rate to go up. Is that?
You're saying because it's taking that parcel off of the tax roll.
Right.
Yeah, I think that really doesn't apply to tier 1. I would have put up a lot more solar faster if I didn't have to pay property tax anymore.
It doesn't apply to the parcel writ large. The same amount of income, at the parcel that's coming now would still be there. It just wouldn't under the law, it wouldn't go up.
It wouldn't be assessed at a
It
higher
wouldn't be
value.
assessed at a higher value.
Yes, that's might be what you're getting.
Taxes still have to be paid like they were in the past.
There are routine, as we say, post-benefit agreements and payment in lieu of taxes, but those exemptions last 15 years. Once the 15 years are up, that goes to full. Well,
So let me restate just so I understand. So if property pays $500 in real estate and school taxes, and it's tier 4, then the taxes it would continue to pay after the solar panels are installed would be the same.
that's how I understand it.
Okay.
The town can opt out of 487, but then that would apply to all solar projects for every.
Would it be on a project by project basis?
And that's, instead of that, that's why the pilot and the community benefit agreement have been rolled out, is to seek compensation, especially by the municipality that bears the burden of the application. Whereas pilot agreements go 50% school, 25 county, 25 town. So a host community benefit program is definitely something.
So let me just state that then. So if because of what's happening in tier 4, there's a solar put there and it adds a burden, burden to the town, then you can do a pilot payment in lieu of taxes. That's part of what the town could do, correct?
Yes.
Okay, but it has to be negotiated, and one doesn't know if you come to terms. And
Well, there's an IDA that does that, Industrial Development Agency.
There's two ways. One is IDA and the other is non-IDA. It's a little bit complicated, non-IDA. And it's a multi-related includes
Thank you.
the town, the county, and the school district.
Okay, yes,
I have another question about, or a question about the tier 3. So we're theoretically would allow 3 of these to happen in the town of Chatham. Is that for private property and municipalities?
It doesn't specify, it would be across the board.
Yeah,
it
so
doesn't-
if the town
doesn't
wanted,
discriminate.
if the town wanted to put solar on 60 of its acres, right, they'd be allowed to do that, and then that would allow one piece of property?
That would allow a third to come in.
And I want to say this law has been going back and forth, that cap and not cap, that's going back and forth. The current draft doesn't have the cap in it, so that's something we should, it's a little bit different than what Michael said in presentation, so it's something we should bear in mind.
Just so I make sure, I think the current draft does have that in it.
The current draft does have the cap at 3. The town board, a couple of meetings ago, weighed in. I think 4-1 that we could do without the cap, but I think one of the town board members felt strongly we should keep the cap. So that was the advice coming back from the town board.
please bear with us, folks, it's 25 pages of text, it's sometimes hard to keep track of all the different shares.
Let's just say, it's not, it could go either way in the final, it's not in any way settled, is how I do it.
Yes, in the back again.
Yeah, so, with the overlay zone, in terms of like keeping us, from getting sued, for the tier 3 projects, I mean, is that a significant area to not be like, oh,
This raises another interesting kind of gray area as it applies to the public utility variance standard, right? Because foreseeably, a developer could come and they could maybe see a parcel that they really like that's outside of that zone, and they could seek to proceed under use variance to site their project outside of the overlay. That's not a question that's been directly addressed by a court, right? Where if you have already laid out feasible properties other than an overlay zone, and the developer says, you know what? There's another feasible one outside of it. I think by just a plain language or proof point, that would be allowed, but a court hasn't looked at that directly yet. So that's, I wouldn't call it a high area of legal exposure, but there's an argument to be made on the other side. It's this lovely kind of ambiguity we're operating with right now.
yeah, I got you, because I know that, when I talked to Morris, they said that the smaller developers are gonna come poking around Chatham eventually, and that eventually has them. I think they have been poking around for a while now, but not in those areas that you highlighted.
It's going to be, it'll likely be a negotiation. I mean, it really will be a situation where, I think a lot of people, the one piece I would counsel is that these developers, they're rational, profit-motivated folks. They're going to see passive least resistance, and I find that many of them are fine working rather hand-in-hand with municipalities, especially if it's a town that can show that they've got a real good faith law in place that gives them some room to run. Why expend the extra time and effort fighting upstream, looking for sites that are going to be tougher and encounter more local opposition from, unless it really suits what you're looking to build. So with this, you're laying out some nice, easy turf for them to play this application game on. And it works for them. I find that a lot of them will play along. There's always, there are developers that'll play hardball for one reason or another.
Gotcha.
Do you feel that the existence of the overlay would more likely compel, if there was a variance granted, that it would compel any future proposal to go close to those overlay zones, more likely closer than not close?
I think it would really depend on the compatibility of the surrounding land uses. And you also got that issue of the length of their eventual interconnections, the electrical lines, and the capacity that goes along with that. That's going to be their main argument in terms of feasibility. It's like, how easily can we interconnect, right? That's really what they're looking at. So, and you work kind of up and down those wires where they likely look.
Okay, I think, did you have a question?
Yes, I would like, are you pointing at me?
Yes, in a way.
Okay, I would like to know, I've heard from firemen that if you have these on your roof, that they will not go in if there's a fire.
If only we had some firemen to talk to.
I'm just thinking, and I'm disappointed because there's no firemen here that I'm aware of. And I would have thought that they would be.
There is language, we didn't want to get into adding into this code, because it's 25 days long, adding into the code everything that also they have to do. We do reference other New York State fire codes and so forth that talk about having distance separation so that people can access onto the roof in the event of emergency, and perhaps, I believe, break into the roof for ventilation purposes, for fire access. We did specifically get into that in this code because those guidelines and standards are already documented elsewhere by New York State and other agencies. So you don't see it in here, but it's referenced, and Angus is rubbing his face and wondering.
No, Angus and the committee did consult, even actually the chief of this fire department.
Well, I was a member of this fire company that told me that, so.
So,
I would also like to say I'm Vincent against them. I think they're ugly as hell. And if the one over on 32, no, not firemen. The panels. And the fact is, I would like to know how much money, for instance, you're using the town garage. I think it would be nice if we knew how much of a savings there will be in a year's time. I understand these things are very popular now and that we're going to have some rules, but I'm against them.
I can talk to you about the town garage. Probably not everybody.
But
I just want to say, we did discuss it with the fire chief. His recommendation was different than what we eventually went with, which was to refer to the state code. He had written some other things which were I think different than the state code. And we decided that it was more appropriate to stick with being in the group than to go off on.
Because also those codes can change. So that's why we just referred to them. But to your point, Ed, you said you feel these installations are often ugly. You're not the only person. I've heard that from.
Well, 32 is a perfect example, and I wouldn't want it near my home.
I understand that the goal of what we're trying to do right now, there's not really any control. We're trying to add a modicum of control to it. So hopefully it will be
I can say that 32 would not be allowed under this code.
Are any of the other towns in this county, I mean, have they set up solar laws?
Yes, I know Kinderhook, for example, right now they have a solar law on the books, which is much weaker than this but they are now, right now, I have inside knowledge, they are considering more strict language, updating that code to be more strict and do some of the things that we're doing here, such as limiting it by agricultural potential in soils and view sheds and so forth.
And just to give you, if I can just do one last point on that. We see, this is not an issue that's unique to Chatham. This is a reckoning that's really going on with a lot of upstate municipalities as they're considering. I mean, it's a land use which likely wasn't considered. Even if you have a comprehensive plan that goes back to the early 2000s, it likely couldn't have envisioned the proliferation of solar energy to the extent that we see it today. So there's also centralized model laws that come down from the state through NYSERDA, which is the kind of organization that they'll flow from. So a lot of communities have adopted laws just about in line with the model law, but we're seeing more and more communities have to contend with this development increases.
Yes.
There's quite a bit of land in the town that's covered by conservation easements in partnership with the Columbia Land Conservancy. Would agreements with the Land Conservancy affect any of this?
Yes, I mean, I believe that their easements were probably written with their own conditions in mind. I imagine most of them, if I'm correct, most of them wouldn't allow some of this.
Would not allow solar.
Right.
They haven't said so though, probably, because it was too long ago that it was done.
Well, when they have an agricultural complex that they develop with the homeowner, they're allowed a certain amount of non-permeable surfaces, and that's considered within it. But it would still have to fall within our land use regulations as well.
In the pink.
I just have a specific comment of setbacks for tier 3 solar energy systems. I just feel like it should be made simplistic and to protect as much as possible, and it should just be matching letter C. I think you should strike D, personally.
So you're saying match C and strike D?
Yep. I think B should match C and you should strike D.
I'm not, could you just give me a recap of what those are?
Yep, B, a minimum side and rear setback of 100 feet with parcel not containing existing residential home. For ones containing existing residential home, that's 150. And then D says they could be reduced to no less than the principal structure setback of the underlying zoning district, if agreed to in writing by adjacent non-participating landowners. I feel like that is, why is it so wiggly? Just, if we're trying to protect, let's just protect.
Okay, I know the part we're talking about. Okay. There are a couple other hands back there. We have two competing firemen here.
three separate parcels contiguous, A, B, and C, three separate landowners. A and C agree to sell to a developer, B does not. Is there any possibility of the use of eminent domain on B, either directly or through the municipality?
Oof, I'm gonna pump that one.
At the heart of all of these agreements is a consensual agreement between a private developer and a private landowner. You know, the way that these utilities are regulated, these solar developers, while we've kind of taken transmission away from production in the electrical generation space, these solar developers do not have eminent domain authority. So if there's no contractual lease or sale of land, that project never gets developed in the first instance. So that's not something you guys worry about as it pertains to solar development.
Thank you.
Just cash.
Yes.
Mine's just a point of information regarding the woman's question about fire company responses. One of the issues with solar panels is the inability to safely and reliably de-energize them because the electricity is generated right at the panel. So if there are panels on a roof, for example, yes, you can ventilate, but you can't also be sure that electric, normally you cut off the electric going to the house, but you can't actually guarantee that when you're cutting through something, even that's not covered by solar panels, that there aren't electrical wires going through, they're still energized. So that's a big issue with it.
Thank you.
Yeah.
The traffic shut down now.
Okay. Yes,
Hi, I'm curious about two things. When the committee, I guess it was the committee who was trying to, who was doing the assessment of possible overlay zones that were contiguous to the power lines, did the committee at any point look at whether there was any likelihood at all in the town of Chatham for a larger site that a developer could come in and say, well, this actually I could build a 100-acre thing here, and it's perfect, it fits all of your criteria, except it's too big. Does the town have such a site that's feasible? And I'm also curious from Michael, the lawyer, given all of this work that the committee's done to protect as much as possible, with that final no tier 4, how do you feel about this law? What is your, I know you can't predict, but it's stronger than many.
Yeah, I agree with you. The fact that we are sitting here having this iterative conversation about this law with this policy framework in mind puts you all miles ahead of a lot of municipalities that I've done work in, both for developers and in representing the municipality. You know, you have really thought about this and set this out and grounded it in your comprehensive plan. And that is the legal basis on which all this stands on, from your perspective. You know, the developer will have their own weapons to use in that argument, but as far as the work that's been done, you're all party of it, it looks good.
To answer your first question, does the town have such a site?
Yes.
We have not done a parcel by parcel analysis of, so we did not do it at that level of detail. We were more looking at what areas of the town, and we want to make sure we want to protect.
I want to say also, I don't think it's really possible, because it's not necessarily parcel by parcel, because it could hypothetically.
You merge two or three parcels together to make something, and we can't predict, oh, well, those 3 landowners would never agree to that. So it's hard to model that. Yes, in the big, oh, I'm sorry, the black sweatshirt hasn't gone yet, I don't think.
Yeah, I mean, can I just take a moment to say thank you? You know, solar energy's been around for decades, but it's pretty new to the rural communities like ours, and I'm just really impressed that the details and the nuances that you guys have gone into to protect this community from overdevelopment, from all the concerns that everybody has voiced, and I'm just impressed, and also being open to the comments of all the really smart people in this room. It's really, really, really great to hear.
Thank you. And then just a quick reminder, we're leaving comments open until July 6th. Okay, yeah. Those handouts in the back, I think.
Yep, I think the definition for native perennial vegetation needs a bit of work because the list of prohibited regulated invasive species that DEC has is quite limited, and they have delegated a lot of that to the local prisms. So maybe you could kind of massage that definition to maybe just say under the ECL, because there are more invasive species that are a problem here than
Sorry,
what are
under which?
prohibited.
Under the,
Native perennial vegetation definition, so.
yes, I got that, you were saying under the, what was it, ECL?
Yeah, so under the ECL, invasive species are defined kind of loosely and vaguely, and DEC, they have a much shorter list of prohibited regulated species, but we have a lot more invasive species that are concerned here, so I think that just needs to be tightened up a little bit. And then I do think we have kind of a glaring omission about the impacts of solar on grassland bird species, so I wonder if that is, in addition to whatever we figure out for forests, something that could be done for site plan review, that they should be doing surveys for grassland birds for the larger arrays.
Okay.
Okay.
Okay, not kicking folks out, but please make sure you grab one of these in case you have someone at home who would like to make a comment and so forth. And thank you all for coming.
Okay? Good job. Thank you.